Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
So basically, this is about anti-defection. You have studied in your class 12th also about anti-defection, IRM, VRM. I hope you remember all those cartoons and all that. And this is a phenomenon which has bedeviled Indian politics. Uh, and in 1985, the cure was supposed to be made by the 52nd Amendment. 52nd Amendment of the Constitution was uh, made in the year 1985, and the anti-defection law, as enshrined in 10th schedule to the Constitution of India, was enacted. Now, the law has not been very effective, and one loophole which was kept in the law was that if one third of the members defect, that is, leave the parent political party and join another political party after the elections. Before the elections, you can change any number of political parties. Nobody is bothered. Or if you lose the elections, you can change any number of political parties. It doesn't matter. But if you win the election on the ticket of a one political party, or you win the election as an independent, and after the election you join a particular party when you fought as an independent, or you join some party other than the parent party which gave you the ticket for fighting the election, then it is called defection, jumping from one faction to another faction. So that is defection, from this group to that group. This is impermissible as per the 10th schedule to the Constitution of India. And the reason for impermissibility is not very far to seek. It is this joining takes place in return for favors, monetary favors, and this corrupts the body politic. And ethically also, it is beyond comprehension as to how a person who fights an election on the flank of one political party, and to that political party uh, he owes his seat, and as also to the electorate. And the electorate voted for him thinking that he is a member of a certain political party. He goes ahead and joins a political party which is different in manifesto, which is different in the electoral promises made. And therefore, what happens of all those promises and ideological affiliations based on which the voter formed their mind to return him from that constituency. So it is ethically also it is incorrect, and politically, of course, it is incorrect because politically it induces instability, and it also induces the culture of black money in the economy because cash frequently changes hands in these transactions, or ministerial births, lure of ministerial births is there. Therefore, the Indian democratic process is shortchanged for the attractions of power. Therefore, this evil was sought to be curbed in the year 1952, and the 10th schedule in the Constitution of India was inserted in 1985. The one of the loopholes which was present in the system was when one third of the political parties members cut off from one political party and join another political party, then it is not called defection. This evil was sought to be curbed, and it was curbed in the year 2003 by a constitutional amendment. I'll put this constitutional amendment in the study material in the first question to this article. And this was the 91st constitutional amendment in 2003, which disallowed the uh, This allowed one-third defectors from leaving their political party, parent political party, and joining another political party. This clause itself was abolished. That if one-third people are in favor of joining another political party, then it will not be called defection. This has been done away with. Now, what is the situation? If two-thirds of the members are leaving a political party and joining another, then it is not defection. So this is the loophole which is currently exploited by the political parties, and some of the you call it horse trading. That is, some of the MLAs switching their sides and being bought by political parties. Now, this evil is still afflicts the body politic. So let us see when the complete ban is enacted. Not only two-third is also taken care. Now, the present situation is more focused on a narrow issue, and that is a direction is issued by the Supreme Court to decide on the qualification or disqualification of the political party, the members of the assembly, and the speaker conveniently sits uh, on the matter and doesn't take any decision this way or this that way, and allows the defectors to continue in their positions for weeks at end, for months at end, for years at end. This kind of thing continues, and there are several examples. Manipur is an example. Maharashtra is an example, and because of these, the intent of the law in the as enshrined in the 10th schedule is frustrated, and therefore the Supreme Court says that look, when they approach the Supreme Court, it says that this kind of situation is not beyond the pale of judicial review, and we are not powerless in such a situation. It is our duty to protect and uphold the Constitution, and we will not shy away from doing that. The limits within which we can exercise the power of judicial review are also well known to us. We cannot direct the speaker to take a how to take his decision. He is completely free to take his decision whichever way he wants. We will not ask him to decide this way or that way, but we can definitely indicate a timeline within which he has to take his decision. Now the question arises: suppose he does not act within that timeline, then what happens? Then, if he doesn't, then there can be a contempt of court petition against the secretary of the legislative assembly, and also against the speaker. So this is what this article talks about. Now, having said that, let us take up the questions one after the other. 140. Speaker elected from the ruling party delays acting on disqualification petitions filed by the opposition against the defecting legislators. Supreme Court intervenes, directs the Speaker to uphold the disqualification applications as long time had passed in taking a decision. The Speaker resists the decision. What legally reports? Now you see, Supreme Court will never issue a direction, directs the Speaker to uphold the disqualification applications. That will not be done because that is beyond the pale of judicial review. Supreme Court will not direct how the Speaker has to decide. That is a discretion which is reserved to the Speaker within the Constitution. Rightly or wrongly, he exercises his power. It is none of the business of the Supreme Court to usurp his power and say that, look, you have not decided, let us decide it for you. That is not done. But the Supreme Court can surely indicate a timeline within which he has to decide. Speaker's decisions are beyond judicial review. They are not. They are well within judicial review. Speaker has to comply with the court direction. Speaker has to comply with the court direction depending on what is the court direction. Suppose the court direction it concerns the manner within which the Speaker has to decide. So he need not comply with that court direction because that is beyond the pale of judicial review. Speaker need not comply with the court direction. Yes, he need not comply with the court direction, but what is the recourse? Can he just pretend as if the court direction does not exist? No. He has to approach the court once again and tell them that, look, your direction is beyond the tenth schedule to the Constitution of India, and it cannot be enforced because you cannot tell me how I have to decide. How I have to decide? I am also a constitutional functionary. I'll decide in the way in which my discretion tells me to decide. My conscience tells me to decide. You cannot tell me that I will decide. I should decide in a particular manner. I should uphold or reject the disqualification applications. This is not your preserve to tell me. It is my prerogative to decide whether or not the disqualifications are attractive. So I am going to decide that. Therefore, the speaker need not comply with the court direction. Nevertheless, he cannot just ignore the court direction. He has to approach the court and tell them that, look, your directions are beyond your powers. Therefore, you can't do that constitutionally. And the court will, if the court has issued certain such directions, the court will actually amend its order. Courts don't flout the constitutional provisions. Speaker may, in his discretion, agree to follow the court directive. He is not required to. The Constitution does not require him to do that. So he need not. The Constitution does not envisage that institutions should be servile to each other. They should not be servile. They should have integrity and they should have independence. But there should be no dishonesty of purpose. That is what constitutionalism is all about, and that is the burden of the courts to ensure that pure polity remains pure as per the constitutional provisions. Now we come to question number 141. The Supreme Court recommends amending the Constitution to strip the Speaker of the power to decide disqualification petitions and suggests appointing an independent tribunal for the task. Parliament has not acted on this recommendation. Inaction of the Parliament is liable for what kind of judicial redress? Now you see, this is a question. Supreme Court can make suggestions, but Supreme Court cannot decide, tell the Parliament that this is what you have to do. Likewise, Parliament cannot tell the Supreme Court that, look, a particular case has to be decided in this manner, or particular directions have to be issued in a given case. That is not done. Why that is not done? Likewise, the Supreme Court will not tell the executive to implement this scheme or that scheme, or do this or do that, unless there is a compulsion to take that course of action because of violation of fundamental rights which have been guaranteed to the citizen. The courts will not. Courts are loath to issue such directions to the government and to the Parliament, and the government, the executive, and the Parliament are also not required in the Constitution to comply with the requirements of the Constitution. They are independent authorities. They can take their own action. Likewise, Supreme Court also is an independent authority. So these are coordinate authorities which are equally sovereign within their own rights, and therefore they have to comply with the provisions of the Constitution. They don't have to pass directions against each other. That is not envisaged in the Constitution. And then the question arises, how they function. They function by self-restraint. There is no other rule above them. They purely function by self-restraint. This is a case of legislative restraint or parliamentary restraint or judicial restraint, or for that matter, executive restraint. They are expected as constitutional functionaries to remain within the realms of their powers and not to transcend them. This is the principle of separation of powers, the checks and balances as institutionalized in our constitution and as also in other constitutions, in other working constitutions, effective constitutions like the US Constitution. UK Constitution, of course, is unwritten, but that does not mean it is any less effective. In fact, it is the mother of all constitutions. Now, question number 141. Supreme Court recommends amending the Constitution to restrict the power to decide disqualification petitions and suggests appointing an independent tribunal for the task. Parliament has not decided on this recommendation. Parliament may decide, Parliament may not decide. It is their prerogative. So, Supreme Court wanted to make a suggestion. They have made a suggestion, and the Parliament has heard their suggestion. They may agree, they may not disagree. That is their domain. The Speaker is liable for contempt of court. No, he is not. Speaker is not liable. Of course, he is not liable. Speaker lacks the authority to decide under the Constitution. He doesn't. None of the above. It is none of the above because Speaker does not concern the Speaker at all. Inaction of the Parliament is liable for what kind of judicial redress? There can't be any judicial redress if the Parliament does not implement the laws that the Supreme Court wants, or Parliament doesn't take action unless there is an implication of violation of rights of somebody. Suppose the MPs are there and their rights are violated. The Article 192, I guess 192 of the Constitution, which guarantees free speech in the House. If that article is violated, then definitely, and clubbed with Article 19, a member of Parliament has almost complete complete freedom of speech and expression. It is subject to very minimal safeguards. The law of defamation doesn't apply. So it is subjected to very minimal safeguards that you shall not discuss the conduct of a judge on court or off court. That kind of limitation is there. Apart from that, there is literally no limitation, no defamation, nothing. So suppose his right is violated, then the Constitution will have to pass directions because it has to uphold the Constitution. It has to uphold the rights of the people, and people include the rights of members of Parliament, members of legislative assemblies. So therefore, to that extent, if that implication is there, that direction will have to be complied with because those are enforceable rights under the Constitution, and those directions are referable to those enforceability component in those rights, and the Constitution, the the apex court is well within its powers to enforce judicial review in these circumstances. But in other circumstances where there is no implication, a suggestion is made by the Supreme Court to any other constitutional authority, then in that case, that is to say the government or the parliament, then they are independent authorities in their own right, and they need not, they may or may not comply, they may or may not agree. They may have their own solution, which may be different from what the Supreme Court suggests. Now we come to question number 142. The Malayalam movie Impuran, referencing the Godra rights of 2002, include the text God 2002 India. Now you will remember that in 2002 Godra rights took place. Godra routes, predominantly a large number of Muslim members of the Muslim community were literally slaughtered, and the governance. There are suggestions that governance was either countenancing or it was ineffective. Now, on this theme, the film has been made, and the film board prescribes removing this text and replacing it a few years ago. So, God 2002 is being sought to be replaced. That you just don't make reference to Godra rights, but replace this expression with a few years ago, citing concerns over public order and potential communal unrest. So those are the concerns that are cited by the state government. The filmmakers argue that the change infringes on the artistic freedom protected in Article 19(1)(a) of the Indian Constitution, and reference is crucial to the narrative. Decide. Now, in this case, let us examine the choices. Basically, Godra rights took place in 2002, and the rights were so severe that a large number of members of minority community were killed, and the election commission was constrained to observe that the atmosphere is so vitiated, it is so polarized between Hindu and Muslims that free and fair elections could not be had, and therefore the elections were postponed. Such was the such was the such was the situation of fear that was induced in the electorate, in the society. There was fear all around. So, in that polarized environment, the elections were deferred by the Election Commission of India, and this movie, which has been made, a Malayalam movie, basically makes a reference to the Godra rights by God 2020, 2002. This is how the movie starts. This is how. So, uh, this expression God 2002 is replaced by a few years ago. In that context, if the artist says that no, it is challenging my artistic freedom, then what options are available from a constitutional perspective? Let us take a decision on that. The first one is that yes, because the board can impose prior restraint to maintain public order under Article 19 plus 2. Now, board can impose prior restraint. That's all right. Their power we are not questioning. What we are seeing is whether the restraint is desirable under Article 19 clause 2. So power is not a problem. No, because the artistic freedom under 19(1)(a) is subject to reasonable restriction, and the restriction does not appear to be so. Yes. So Yes, if reference to Godhra 2002, India is likely to incite communal disharmony. So, if reference to Godhra 2002, India is likely to, yes, all right, then no, because the film board's actions conflict with the certification granted. So, what is the certification granted? We don't know. This is not written here. Argue that change infringes their artistic freedom protected in Article 19(1)(a) of the Constitution. They are only saying that look, this is our freedom of speech and expression, and they are not talking about film board certification. Therefore, 4 becomes irrelevant. This is not the situation. If reference to Godhra is likely to incite communal violence, then what is Article 19 clause 2 saying? Let me refer to Article 19 clause 2 to refresh your memory so that you understand whether this is permissible. And besides, when you reproduce the article, then in a particular context, then the kind of impact it has, it does not have keep when you keep looking at the article in different contexts, it may not create that impact. But when you look at an article in a given context, it may create a better impact. So I'll just refer to Article 19. All citizens shall have the right. So citizens have the right to freedom of speech and expression, not to freedom of speech and expression. What are the reasonable restrictions on this? This is given in Article 19, Clause 2. Here it is. Nothing in the subclause A of Clause 1 shall affect the operation of any existing law or prevent the state from making any law in so far as the law imposes reasonable restrictions on the exercise of the right conferred by the said subclause. Said subclause is the clause subclause A of 1, which basically talks about the freedom of speech and expression. Right now, said subclause in the interest of sovereignty and integrity of India. That is one. Second is the security of state. That is another one. Friendly relations with foreign states. That is another one. Public order. That is another one. Decency or morality, or in relation to contempt of court. That is another. Defamation. Another. Incitement to an offense. So these are the reasonable restrictions which are available. You will notice that law and order is not mentioned here. Public order is mentioned here. Public order. National security is mentioned here. Security of the state. Sovereignty, integrity of India is mentioned here. Decency, morality, contempt of court, defamation, incitement to that. Therefore, the film board surely has the power to ban the film if there are implications for public order. It has the power to impose reasonable restrictions if there are implications for public order, and this can be done by executive instructions also. So, having said that, let us refer back to the article. Yes, if reference to Godhra is likely to incite communal disharmony. So, public order basically amounts to public order offences are offences of communal disharmony, communal rights, civil commotion. All those are communal. All those are the things. And security of state. You have already studied what is national security in your class 12th course, and basically security of state means that the if I have to explain to you what is national security, what is public order, what is public safety, and what is law and order. I will just draw here a picture. This is one constant. This is one circle. Inside that circle is another circle. All right, and inside that circle is another circle. Now this circle is comprising of offences of national security. All right. All right. This circle is comprising of offences of public order, right? Public order. This will include communal rights, civil commotion, and all that. The damage to property, public property by mobs, all that. Then this circle is the biggest, and this will include law and order, right? This is law and order. Therefore, every situation of law and order is not a situation of national security. And every situation of public order is also not a situation of national security. National security you already studied in your class 12, or you will be studying in class 12 in world polity in political science. That national security comprises of those very minimal number of offences which threaten the existence of the state. So if the state's existence itself is imperiled, it becomes a question of national security. Otherwise, it is not a question of national security, right? Nowadays, there are two kinds of views on national security. I need not dwell very deeply on that. National security basically talks about the modern view of national security and the earlier view of national security. The earlier view, pre-modern, the earlier view of national security basically was when your referent is only the state, when the existence of the state is imperiled. But the present, in the present conception of national security, the referent is not merely the state, but also the individuals who reside in that state. The citizens and nationals of that state are also. Now, when pandemic like HIV strikes, like pandemic like COVID-19 strikes, when other pandemics strike, when there are when there is a disaster, then in those situations. So all those are also in the present um, thinking. At the present dominant thought is that all those are also in stance of national security, because where the existence of the individual is imperiled, not the individual as such, but individual as a member of a group or a whole nation is imperiled, then it is a matter of national security, right? So having said that, public order is an offense against which the state is has been given the power to basically intervene if the movie will have an impact on public order. Now you will ask me here. You may pause and ask me here that, look, is this not violation of free speech? Now you see, equality is equality among equals. Unequals cannot be made equal. Article 14. Let me refer to Article 14. What did he say? Let me pull out the text of Article 14 so that it becomes a little clearer to you. Article 14 says this. It always helps to refer to the Constitution again and again because we are reminded of those great principles which are enshrined in there. Now, the state shall not deny to any person. Let me share it. State shall not deny to any person equality before the law. Um, Article 14, where is it? Uh, yes. Yes, it is there. There is Article 14. That thing is coming. I'll have to remove that. Let me remove that just one moment and I'll remove that. Freedom of speech, where is that one? Just one second. Let me remove this because this will keep coming and it's spoiling our spoiling the visibility of let me just I removed it. Yeah. Yes. Now Article 14. State shall not deny to any person equality before the law. So that is so when you are imposing film restrictions, what the Supreme Court says is the equal protection of laws within the territory of India. So what happens of our equality? What happens of the equality clause? When you are arbitrarily making cuts and edits in the movie, then it violates Article 14. Because such cuts are not allowed in freedom of speech and expression, except when certain reasonable restrictions are breached. Then why do you have this pre-censorship of films? You don't have pre-censorship of spoken word. There is no question of any pre-censorship. And those petitions by Elon Musk and other companies are already lying in the Supreme Court that this kind of pre-censorship is not allowed. Censorship was undertaken by the Congress party, by the ruling government in 1975 under Indira Gandhi's premiership. Censorship, they installed an entire mechanism of censorship, and thereafter they have not done it. Recently, there have been some attempts by for on the ground of spreading disinformation on that, and the attempts have been largely rebuffed by the courts. Courts have not been too keen in upholding these attempts. Pre-censorship is not permitted under Article 14. Under Article 19, pre-censorship of the freedom of speech and expression is not permitted. If pre-censorship is not permitted in matters of speech, why pre-censorship? Why do we have a board of film certification which certifies whether this film is fit for viewing or not? Then, if you compare the field of the movies, uh, that is the media, this media, with the print media, then how do you justify? There is a lack of equality. I hope you appreciate the argument. The pre-censorship is not permitted in matters of free speech under Article 19. Therefore, you can't tell the press what you have to publish. If the newspaper starts publishing articles, incendiary articles, which pit one community against the another community, and create situations of public order, then in that case, appropriate recourse can be had against those newspapers as per the law, and the executive is empowered to pass appropriate directions. But before publication, they will not be able to do all that. But in case of movie, you have an entire apparatus in which pre-censorship system is set up, where they will tell you that you cut this scene, you cut that scene, you cut this script, you introduce that part, you cut this display on the screen, and all those kinds of directions are being passed routinely by the Central Board of Film Certification. So much so that they are also saying this film is fit for exhibition for on universal basis. This film is fit for exhibition on S basis, that is to say specialists only, which is rarely granted for particular professions like doctor, medical, doctor, lawyer, like engineer, like members of the armed forces. This is not granted. That certification is there, but not granted. Not those kind of certification is not done in practice. Then you have universal exhibition. You have universal exhibition with caution for children, adolescent children, and all those. Um, then you have A-marked films which are not meant for certain age groups. They are not to be shown to them. Why this? How can it be justified under Article 14? The reason is the equality is between equals. Equality, unequals cannot be made equal. Print media and the other media, which is the television media or video media, whatever you call it, the other media, the print media is different from the electronic media. There's a day and night difference between them. When you watch a movie, the impact of the movie on the mind stays for a lifetime. It doesn't go anywhere. The impact is so deep, the impact is so profound that it will not go away anywhere. It will stay in your mind. Therefore, it has more chances of spoiling the morals of impressionable minds and inciting violence at the level of public order or national security. That's why these unequals cannot be treated equals. That impact of the movie is far more than impact of the television media. Nobody has told us that we will ban the newspaper, but everybody tells. Even Australia and several other jurisdictions have passed laws which say that we will not allow social media for children. Even that to that extent. Why not allow? If nobody says that for print media, because those media, electronic media and print media, are inherently different in the impact that they have on their audiences. That is why the Supreme Court in various cases, including that famous artist Fida Hussain, MF Hussain, MF Hussein's case, also the Supreme Court said that they are different and we can't equate them. That's why pre-censorship of movies, we can't say that it is violative of the Article 14, because the the impact that it creates is very huge compared to the impression that it creates, that the print media creates. Having said that, therefore, the likely to incite communal harmony, yes, the power is there with the state government. No, because artistic freedom is subject to unreasonable restrictions, and restriction doesn't appear to be so. Restriction appears to be so, or restriction appears to be so, is the matter of the film board. We are not to decide on that. Because because the board can impose prior restraint to maintain public order. Board can impose, that is true. Whether or not it is a fit case for imposition of the restraint, that is their discretion. We don't have any. We will not subject judicial review once again. Will not go to how the board decides, but on what procedures the court followed to decide. The distinction is very subtle. It is not like judiciary sitting on the on each and every authority and then telling them that this is what you have to do and this is what you have to do. No, that is not their job. You do your job, we do our job. Our job is to just to tell you that look, whether you are within the constitutional confines or not, you have every power to exercise. You do it, but do it within the constitutional confines. You have every power to impose your film board has every power to impose restrictions upon upon the exhibition of movies, but do it within constitutional confines. You can't say I don't like this director, that's why I will not allow his film without so many cuts. That cannot be done. You can do that, but you can do that. Your action should be referable to the restrictions under Article 19 Clause 2. You can't allow it to become arbitrary, because the moment you become arbitrary, you are violating Article 19 Clause 1A, and you are read with Article 14, because then something else has come into existence. What is arbitrary is unequal per se. So that is the point that is involved here, right? Now I come to question number 143, which is answered very nicely by all of you, so I need not bother about this. A well-known painter creates a controversial piece depicting a sensitive subject. Look, did we do the bring what I'm saying makes sense? Because you already have a pre-read and you know what I'm talking about. Please read and tell me. You should have pointed out first. You should not have allowed me to go forward. Because the kind of effort I'm making, it makes sense only when you are on the same wavelength as I am, and you can be on the same wavelength only when you make the presentation. Otherwise, how can you be on the same wavelength? It's not possible. It's all in the mind. There's nothing tangible here. So, mind things will have to be dealt with in the mind. Now, please make the presentations quickly. Go through the article and make the presentations. Then I'll resume from 145.
So this article talks about the artistic freedom, and this says that the Indian Constitution gives everyone the right to speak and express themselves freely under Article 19, subclause 1, subclause A, and this includes the freedom to create and share art like books, films, music, paintings, and but this right is not unlimited, and the government can put some restrictions on the on this freedom under Article 19, subclause 2. For example, to keep peace or avoid problems in society. And sometimes the government stops a movie or art before it is shown. This is called prior censorship. And in a 1970 case, K. Abbas versus Union of India, the Supreme Court said that such censorship is allowed if it helps maintain public order. But in the other cases, like the Padmavat film in 2018, the court said that once a movie gets permission from the censor board, states should not stop it just because they fear unrest. And the court protected the film as a part of artistic freedom. Artists can also show bold or sensitive topics in their work. Uh, in 1996, the Supreme Court allowed the film Bandit Queen to show some scenes with nudity because they were important to the story. And in 2008, the Delhi High Court supported painter MS Hussain and said that courts must look at the artist's point of view and their purpose before judging such works. And also, artists have right to stop others from copying their work. In 2019, the Delhi High Court gave an order to block websites that showed pirated movies, and this helped protect creators from theft, and that's all from my side.
Yes.
And Delhi High Court ruled Mother India painting was not option balancing the artistic freedom with public interest. An artist can protect their work from piracy and unauthorized copying. Delhi High Court used India's first dynamic injection to block pirated content website, and artistic freedom is protected and reasonable restrictions apply for the public order and morality. And court balance artistic freedom with the societal concern on a case by case basis. Allow safeguard created for unauthorized.
So this article is basically about the artistic expression under the Article 19 of the Indian Constitution. Now, this comes under the uh, uh, freedom of speech and expression. What it talks about is effectively how this freedom is interpreted by the Constitution and the dimensions of it. So, some key dimensions of the artistic freedom include that restrictions, censorship is applied on the artistic work, and after it is certified by the censorship board, it is allowed to released. It is also held that the state cannot impose any bans on a work that has already been certified by the censorship board. Artists are allowed to depict potentially sensitive or controversial content that may or may not uh, be socially acceptable. However, the courts are also allowed to impose restrictions on such works based on community standards and creative liberty, such as in the M.F. Hussein's painting case, where the court had held that the artistic depiction of Mother India is not considered obscene, and that we need to first evaluate the artistic intent behind the painting itself. It also provides the anti-piracy law by preventing infringement of artistic work. So, in essence, the article basically says that artistic freedom is protected but is not absolute in India,
Yes.
and that judiciary and the court can impose restrictions on such works based on community standards.
So basically, we have summarized this article. Please stop me if I go ahead making a presentation without affording you a chance to make a presentation, because my presentation becomes effective only when you have carefully summarized the contents of a passage. Otherwise, my time is a waste of time, plain and simple. Even if I repeat it 100 times, it will not create the intended impact. It will create the intended impact when we are on the same wavelength, when you have a certain amount of pre-read. So even if I forget, you must immediately stop me and say that, look, this has to be done first. Now, uh, I can also come and make a presentation and go, and nothing will come out of that kind of work. That is why we take so much time. Just we discuss 4 newspaper articles, that's all. And the entire time is consumed. Let it be consumed. That is what is the intent. The the idea is high quality interaction, and that takes time. So let us not be in a hurry. Hurry, haste makes waste. Therefore, let us follow the protocol. And here the article basically talks about artistic freedom, and it interlaces with Article 19(1)(a). Now, if we examine, you all already know the contents of the article. Basically, Article 19(1)(a) provides the freedom of speech and expression. You have seen in the US Constitution the other day that freedom of speech and expression is identifiable with the freedom of the press. It is also identified with the freedom of the electronic media. It is also identified with the freedom of the individual in the street, whether be he a poet, a painter, a cartoonist, a filmmaker, whatever he is. All citizens have the right to freedom of speech and expression. That the right to freedom and expression is available to all the citizens in India, but in the US Constitution it is slightly narrow. We have already seen that. They don't, sorry, in the Indian Constitution it is slightly narrow because they are talking only about citizens. Where in the US Constitution there is no reference to citizens. On the contrary, there is reference to people. And people may be citizens, people may not be citizens, people may be nationals, they may not be nationals, they may be of some other nationality. Therefore, the U.S. Constitution, to that extent, is broader in its terms rather than the Indian Constitution, which confines the right to free speech and expression, and the gamut of other rights and freedoms which are envisaged in Article 19, basically to reserve them basically to citizens. Let me analyze each one of these cases which has been commented upon by the courts. First and foremost is the Abbas versus Union of India. Here, the apex court held that. Let me share this time. K. Abbas versus Union of India, 1970 apex court found that pre-censorship is permitted under the Constitution for maintenance of public order. Now, print censorship is permitted not only for maintenance of public order but also for other aspects. Which are those other aspects? Supreme Court was commenting in the context of a particular situation. That's why they said that it is permitted for public order, but it is also permitted for all these contexts. That is, interests of sovereignty, integrity of India, then security of state, friendly relations with foreign states, public order, decency, morality, in relation to contempt of court, defamation, and incitement to an offense. Is that clear? I guess that is where the court's commentary hovers around, and we should be clear on that. If you can refer what is stated here to the Constitution, it will greatly enhance your understanding. Now, if you come to these courts, have the duty to interpret the Constitution. They don't rewrite the Constitution. They don't rewrite the laws. That writing the laws is the part of the legislature. That's what they are only interpreting the Constitution. And interpretation is not easy, mind you. It is not. It can go to any depth, right? So it is quite a bit of work to be able to effectively interpret the Constitution. Now, if you see the second case which is there, which is quoted in this article, this article is very nicely written. It brings a wealth of insights on the freedom of speech and expression, and quotes all the relevant landmark judgments given by the courts. The second judgment is in 2018 in Viacom. So, 2018 judgment Viacom Media Private Limited versus Union of India. The Supreme Court ruled against prior restraint screening of film Padmavat since had taken permission. So then it says Supreme Court, Gujarat and Rajasthan governments had banned screening on the ground of public order. So you know there is a apparatus of film censorship, and that apparatus we have already discussed is justified, right? The legality of the apparatus has already been justified by the Supreme Court on the ground that the film media, the electronic media is inherently different from the print media. There is no comparison between the two because the electronic media is very profound in its impact, and that's why there is a. It will be like if you treat the two in the same way, you can't have a pre-censorship of the press, but you can surely have a pre-censorship of the films, and that is already there in terms of the Central Board of Film Certification. So that is there, and here they are saying that once the Central Board of Film Certification has exercised its power and granted a film a level of exhibition, whether it is universal exhibition or cautious exhibition. Now, in that case, the state government cannot come forward and once again say that look, it will create a public order situation unless they demonstrate the same in the court. That look, there is really a public order situation. Unless they are able to demonstrate the public order concern that they have, the court will not lightly interfere with the freedom of speech and expression. Let's see how the judiciary raises the bar of performance. How the judiciary raises the same law is there, but then the manner in which it is implemented is very different. The Rajasthan and the state governments taking objections to implementation not permitted once CBFC has given the go ahead, but then still they can go ahead and impose a ban if they can prove to the court that look, that kind of situation is going to arise, and it will surely create a situation of public order, because public order in any case, people's property has to be secured, and you can't sacrifice the same at the altar of free speech. You can't do that. That is too big a price to pay. Now, that is like throwing the baby with the bathwater, which will not be an appropriate thing to do. So that kind of caution they have exercised. But once CBSE has Central Board of Film Certification has granted the certification, then the bar is very high for the state government to come forward and convince the court that look, it will surely create a situation of, because the court will not look at law and order situations. That is not there in Article 19 Clause 2. The law and order situations are not a ground for banning films and imposing any kind of ban under Article 19 Clause 1. Only and only if it transcends the individual and goes to the groups, large groups, then only the the restrictions will trigger in. And the bar for the restrictions to trigger in is not that easy. Once certification has come, then the courts will not lightly presume that there will be a public order situation, and they will not allow those restrictions. Now, if Bobby Art International versus Ompal Singh Rule is another case. Basically, this case we have discussed time and again on what are the standards for obscenity. This we have already seen. We have seen that there is a Miller's test, that there is a Hicklin's test, that there is a there is a there is a community standard that is there. All these and in India we follow the Miller's test. To my mind, the other day we had done that article, and basically community standard test will also be applied, and this interlaces directly with Article 19. How? Let me refer to Article 19 once again, and let me see how it interlaces with Article 19. It interlaces with Article 19 because you will kindly notice sovereignty, integrity of India, security of states, friendly relations with foreign states, public order, decency or morality. Here it interlaces directly with Article 19. That is why it is commented upon very frequently. This is the reason, because Article 19 Clause 2 is a is a permissible, reasonable restraint, decency and morality, and that is why all those Hicklin's test, Miller's test, community standard tests, all those tests will become a part and parcel of this discussion. That is how it comes in. That is how it is roped in. Now, having said that, Makful MF Hussein's case is also on the same what is obscenity, what is not obscenity, and all that, because Article 19 Clause 2 restriction is there. That is why they are enunciating or propounding the scope of Article 19, right? So, Bobby Art International, we have seen this is also discussions on decency and morality as enshrined in the Constitution. MF Hussein's case we have seen. Then there is this UTV software communications. Here the Delhi High Court says that pirated content is not permissible. Piracy is not permissible. How do I relate this to Article 19? How does it come in? Incitement to an offense. Sovereignty and integrity of India, security of states, then friendly relations, then public order, then decency, morality, contempt of court, and then there is incitement to an offense. So this is piracy is an offense. Therefore, reasonable restriction can be imposed on the ground of piracy also. You don't have any right of free speech of pirated content. You can't say that, look, the content is violated, the content is pirated. I have stolen it from elsewhere, but so what? It is my right of free speech. No, that is not permissible. That is reasonable. That is subject to reasonable restriction, and it is correct also. Doesn't make any sense for somebody to take the moral high ground of free speech and then say that I will deal in stolen ideas or stolen copyrighted works. Not permissible, right? So this is what the article is talking about. We have already discussed the questions. I'll not repeat those questions because time is precious. 143. I'll come to 143. So 143 I have answered correctly, so I need not pick on it. 144, controversial piece depicting sensitive subject, Mother India. A petition filed against painting alleging that it is obscene. The artist defends his work, stating that it is social critique and exercise of artistic freedom under 19(1)(a). So, what will you say? One person says that this is obscenity. He says that no, nothing doing. This is my artistic freedom, and I can depicting nudity to convey a message is within my artistic freedom of communicating my view or my social critique to my audiences. That is my Article 19(1)(a) of the Constitution. So how will you decide the competing claims? The claims are based on the reasonable restrictions on the one hand, and based on the free speech, that is clause 19(1)(a) on the one hand, and Article 19 clause 2 on the other hand. They are saying against this, they are saying this is objectionable on the basis of reasonable restriction of decency and morality. And whereas the artist is saying no, nothing doing, you are interfering You are causing undue interference with my rights under Article 19(1)(a), which is free speech. So, what are the options available to us? No, if the painting is found to be to be obscene without serving any public interest. If it is found to be obscene without serving the public interest, then surely it can be the restrictions will win and freedom will lose. Then yes, because the artistic expression cannot be restricted under Article 19(1)(a). It can be restricted. It is given in Article 19 Clause 2 on the grounds of decency and morality. No, because the sensitive subject should not be portrayed through art. That is not the point. The point is how do we interpret the decency and morality as enshrined in the Constitution? Whether the interpretation that we give is uh, is upheld in the painting or it is not upheld in the painting. How the interpretation applies to the painting. Yes, if the painting is considered a social critique and not obscene by contemporary standards, that is the interpretation that has actually been provided to the expressions decency and morality in the Article 19 Clause 2 of the Constitution. Yes, if the painting is considered a social critique not obscene by contemporary standard. Why this is coming twice? All right, I will correct it after the class. 144. C has got repeated because of some typographical error. I come to 145. The 100% correct. I am very happy. Kids have understood it. Now this finishes our article. This finishes our paper 63, and now we have to go to paper 64. And this we will take up tomorrow. Any problems in any part of the work that we are doing that you need to be resolved?
No, sir.
No problem. Tanishka, all well?
No, sir. Yes, sir.
All well. All right. Quickly finish up your articles so that I can forward the next article. The next article is also ready with me. If we have to do one article per day, then we will have to increase our time of interaction to at least 4 hours. From the present, we started at around 7:15, I think, 7:20, I guess, and it was 7:30, I guess, by the time we started, and it is already 8:45. So it is not 2 hours, but we usually take 2 hours, nearly 2 hours, 1:45 to 2 hours. But if you want to do if you want to do one paper per day, 4 articles of logical reasoning and four articles of legal reasoning, that will stretch our time to something like 4 hours. I think we can do that nearer the exam, depending on the time stress we have. Yes, no, indifferent, something, say something, or think about it or tell me tomorrow. All right. Whether we need to stretch our sittings to 4 hours. I mean, to logical reasoning as well as legal reasoning in one day, one paper one day, that kind of thing. There should be no rushing. Rushing will only create a waste. It is not going to create any result. Rushing will not help. It has to be done very, very thoroughly. So think about it, how we can manage to achieve one paper per day. The target of one paper per day. One paper per day is not much. How much time do you take? 2 hours, 2.5 hours to do a paper, maximum 3 hours. And then there is followed by a class of 2 hours. So you have nearly 5 hours more. But still you have another 10 hours with you for your consolidation. All right, but think about it, how we can achieve one paper per day.